Welcome to the Joint Veterans Endorsement Interviews for Judicial Candidates. We would like to thank our sponsors, Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds in Department 29. We'd like to say that Veterans in Politics International and Nevada Veterans Association are going to abstain from participating in this joint veteran endorsement interview because of representation of one or more of the candidates participating. Let's review the rules and format. First, the panel members will introduce themselves by stating their names and the organization they represent. Next, each candidate will introduce themselves. Please include the office you are running for and explain why you are seeking that position. We will then proceed to the interview portion. Each candidate will have 1 minute to answer each question, and I will inform you when you have 30 seconds remaining. When your time has expired, you will be notified by myself, and you will be able to finish your sentence, but please conclude your statement after you finish the sentence. Panel members will not be permitted to ask follow-up questions. After all panel members have completed their questions, each candidate will be given 1 minute to make a closing statement. And again, the panel members are from Armed Forces Chamber and Veterans in Politics International, and Nevada Veterans Association are abstaining from this endorsement interview because they represent one or more of the candidates. My name is Andre Haynes from the Armed Forces Chamber.
My name is JP Edwards from the Armed Forces Chamber.
Okay. Gentlemen, please state your name and why you're running for office, starting with Mr. Ganz.
Good morning, gentlemen. Good to see you. My name is Adam Ganz. I'm running for District Court Judge, Department 13. I'm running, I currently serve as the ADR and Discovery Commissioner. I'm on the bench, and I want to get some more duties and more responsibilities and elevate to the trial court level. That's why I'm running. You asked why we're running. That's why I'm running. I want to give back to the community the best way I know, and that's through the legal system and through the justice system. Thank you for having me.
Good morning, gentlemen. My name is Christopher Howell. I'm also running for District Court Department 13. I'm running for judge because I want to make a larger impact in our community. I've been in public service my entire life as a veteran and now as a public defender for the last decade. District Court judges have an immense ability to be leaders in our community, and I want to help build a better community together with those leaders.
Morning, and thank you for the opportunity to interview this morning. My name is Robert Kurth. I'm also a candidate for District Court Judge, Department 13. I'm running for this department because I care about our community. I care about the place that my family has called home for many, many years. I've raised my children here. My grandchildren are getting raised here. And I think we need people on the bench who have the experience, civil and criminal, and someone on there, like myself, who's going to listen to their concerns, who's going to respect their rights, who's going to uphold our Constitution. And that's why I'm running for this department.
Thank you, gentlemen. The first question is going to come from JP Edwards.
Gentlemen, this is for each of you. JP Edwards, Armed Forces Chamber. What aspect of your legal career have most directly prepared you to preside over the high volume stakes of the 13th District Court? Who's first? Start with yourself.
All right. Well, my current position, I'm on the bench. I've been doing this job for about 3 years. I practiced law for about 25, 30 years before today. And I believe that I've changed dramatically since taking the bench. I've understood how important our system of justice is. As an advocate, you look at representing your client and do the best you can for your client, but you don't see the whole entire picture. And as a judge, I've been able to really see that from the inside out. There's also administrative stuff that you don't realize when you're running for an office. And I believe that the current position certainly allowed me the opportunity to show that my ability to be fair and honest and follow the law is and everybody's been able to see that. So I think that my current position obviously has probably set me up the best, but I also was a Justice of Peace pro tem for 10 years. I currently teach over at UNLV. So I think a combination of everything in my life is culminated in this moment to allow me to be the best trial court judge I can be.
So I would say that it's the last decade plus of being a public defender. I've represented thousands of clients. I've been in court nearly every single day of my career. We've represented people through every single phase of litigation, from arraignment to trial to appeal. I'm in court every single day. We're doing multiple evidentiary hearings a month. We're doing preliminary hearings every week. We're doing revocation of probation. We're doing, writs. We're doing appeals to the Nevada Supreme Court and the Nevada Court of Appeals. I have spent an immense amount of time in court, and I think that uniquely qualifies me for the position.
Let's see. So, as far as aspect of legal career for high volume cases, that's the question, correct?
Yes.
Okay. Well, I've been practicing law for 34 years. During that 34-year time period, I've been managing my own practice since 1996. While doing that, I've also served as an arbitrator for the district court, where I get appointed to work on cases for the last 25 years, since 2001. Even while handling my office as a solo practitioner, running from municipal court to justice court to district court to different locales, Henderson, even up to Reno, in handling cases. I've handled high volume commercial business cases. I've handled high volume or high criminal cases, very serious criminal cases, and very serious business cases. And I think that those transactions, along with appearing before the Nevada Supreme Court, the Nevada Court of Appeals, the Utah Supreme Court, Utah Court of Appeals, has given me the direction and the information, the guidance that I need to be a successful district court judge.
Andre Haynes, Armed Forces Chamber. This question is for all three of you gentlemen. Should it apply? It's a multi-part question. Have you run for office before? And if so, how has that best prepared you for office now, should you be elected? And you could start, Mr. Howell.
I should probably start. This is my first time running for office. I don't have any experience running a campaign or running for office or for judge. This is a simple answer.
Go ahead.
I've ran two other times. Once was in 2020. I ran. I had a primary. I won the primary. I lost at the general election. Then again in 2022, there was a special election. There was a very short period for an open seat. That was about a 3-month campaign. I ran. I lost by a couple of points in that election. I can tell you that it's prepared me, because there's a lot of the groups out there like yourselves who judges need to get involved in and understand what they do and how they operate and what's important to them. And I think that I've been campaigning pretty much for 6 years now, to be honest with you. So I've never given up the passion that I have to become a district court judge, and I'll continue to work towards that. And I think that the losses sometimes will give you more information than the wins sometimes. So I'm certainly ready to move forward and take a win this time.
Robert Kurth. Yes, I've run for office before, and I think that doing that, you get out there and you meet people from all various backgrounds, just like I have met during my practice, and you make groups. I would agree with Adam there on that, and you see some things that they want and some things that they are looking for, how they look at and interpret the judicial system, and it has given me a better perspective to consider that from all different. Whether I was meeting with, for instance, like the Clark County Black Caucus, I think that was what it was called, or the Veterans Association, or seniors, or other various groups. So I think that has definitely benefited me to see how they understand the judicial system, look at it, and what things that I could do when I'm elected judge to make it more beneficial for everyone.
J.P. Edwards, Armed Forces Chamber. This is for all of you. How do you interpret your role in managing courtroom efficiency without sacrificing litigants' due process rights?
Who's first? Robert this time?
I'll go first. I'll give you a break.
That's okay.
Due process is the most important aspect of the judicial system. You have to ensure that everyone receives due process, right? We have a presumption of innocence. And even in your civil cases, I do a lot of civil litigation cases. Is everyone getting their time? Is everyone able to express their feelings? Are they able to express their position? And some people have more difficult time than others, right? Now, sometimes you don't see as many pro se litigants in the I see a lot of pro se litigants when I'm practicing in family court, but in the regular district court, civil criminal, you don't see as many in there, but you do see some, and you have to make sure everybody understands the process. They get their day, they're heard, and they understand that you're listening to them, right? They need to see that you're listening to them, because when you make that decision, it's going to be easier for them to accept that decision if they feel like you've listened to them and evaluated all of the evidence. But I mean, there's a time where you have to probably stop things so you can get your work done, right? You can't let somebody go on for hours and hours. Yeah.
And from my perspective, that was one of the biggest things I've learned since being on the bench is how to manage that time, because you're extremely busy. I mean, we have a huge caseload, and it's definitely something that's necessary to manage in that way. And by owning businesses, I think Robert talked about this as well. By owning businesses, you learn how to manage that a little bit. But being on the bench, due process is absolute number one. I mean, people have to have their right, and they have to have their ability to be able to say their piece and within the constraints of the law. A lot of judges are doing minute orders. I will like to, the number one thing that I like to do, and Robert knows this, he's appeared in front of me, is I like to give you a kind of a preliminary thought of where I'm going. I'm prepared, I'm ready to go, I know where I need to go, and I know what the pleadings already say. I just want you to supplement that a little bit so we can kind of narrow it down to what the issues are that I need to focus on. So I'll usually tell people that, where I'm going and what I'm looking for and what I need from them in order to move that process along, but always give them the opportunity to tell me what they like in order for they can protect their record.
So due process is a constitutional right, and sometimes that right requires, and most times requires, patience, and that has to do with temperament. You have to respect the people who are in front of you, to give them the opportunity to get their full argument out. But you must be prepared for that argument. And they, again, supplement their pleadings so that you have to be prepared as a judge so that you can make a decision after you've heard argument on a case. But there is no substitute for due process. It is a constitutional right. And we have to respect that, and we have to adhere to that at all times as judges.
Andre Haynes, Armed Forces Chamber. This question is for all of you gentlemen here, and it is: how would you handle a situation where a major campaign donor appears before you in court?
That's tricky, isn't it? People think that it's harder than it really is. And if you have a belief and a passion for the truth and justice and to follow the law, it's not as hard as people think. Yes, people do give money. That's how our system is set up. I'm not suggesting that it's the best system, but it's certainly our current system. We don't get to make those decisions as judges. But I will tell you, it does get you out in front of people like we talked about earlier, and you do have the opportunity to hear from people and what their concerns are within our community. But I will tell you that it's a balance. And the way I do it as a judge now, I will check myself. We all have inherent bias. We all know that. I mean, if you're sitting there saying that you're not biased towards something or someone, you're being delusional. However, will it affect you to be able to apply the law the way it's supposed to? And will you be able to put that aside? I often will check with other colleagues to make sure that I'm not missing something. Hey, am I seeing this thing the right way? Making sure that I'm checking those inherent bias to make sure I do the right thing for the community and that case.
So there's actually a law point in this, and it has to do with disqualification and recusal. And, you have certain people that cannot appear in front of you. You have the best man in your wedding, for instance. And there's certain issues that you can't hear, because of who the parties are appearing in front of you. You also have a duty to sit as a judge, which means you have to weigh the personal connections you have with the people who are appearing in front of you versus the trust and transparency of the judicial process. And you have to give the parties an opportunity to argue if they don't agree with whether or not you decide to recuse or not, or whether or not you've decided to disqualify somebody or not. So ultimately, it's going to matter on those facts, and every party should have the opportunity to make their case that you should or should not be allowed to hear a case where parties who you have a connection to are present.
Robert Kurth. Since our situation right now is where, people are out there raising money and they're contributing to campaigns, even they do that in like the assemblymen, the Senate races, things like that. They want them to vote on certain bills and things. They have different standards. But as a judge, as a judicial officer, we have to make sure that we're unbiased, right? And that there's no appearance of impropriety. Now, I think that when people are mostly donating and attorneys are doing it, they're looking that, hey, we want to make somebody on the bench that is experienced, that is going to be fair, that's going to be just. And attorneys understand their case. They understand the facts and things that are there. And I think they accept, even if they are doing that, if you rule against them. And if the facts are such that, you're not going to just rule in favor of somebody because they donate to you. If I felt that I was influenced at all, one way or the other, then I would recuse myself, most definitely.
J.P. Edwards, Armed Forces Chamber. Y'all two jumped the gun on the next question. So I'm going to this one. How do you ensure your rulings are grounded in statute and precedents rather than personal philosophy?
I thought we were going down the line here. But
Okay.
Sorry.
I've had many cases, and that's one reason why I'm running for this department, because of my civil experience that I have and my criminal experience. Because sometimes you get in there and I deal with some judicial officers, and I think they should be looking at a summary judgment, that they're not really paying attention to the law. They're letting things go on. It's causing other litigants to incur unnecessary and increased attorney's fees and costs. So we have to look at the law. I'm not one that's going to legislate from the bench. If the legislature made the law, if I don't agree with the law, I might not agree with it, but I need to apply the law to the facts. And if that comes out with a result that I particularly don't agree with, it doesn't matter. If there's something where we need a little bit more research on it, then we're going to go look at the legislative intent, right? How was this particular statute created? We're going to look at somebody says, well, this case applies or that case applies. And a lot of attorneys argue that. But when you look at in particular, the facts are usually a little bit different. They're usually not directly on point. So you just need to consider everything involved.
I would agree with everything he said. I think that it's very important to realize that judges don't make the law, and the judges that do, I think, are stepping over their bounds. I will not legislate from the bench either. I believe it's very important and to be an advocate for the system and to make sure that the system is fair for everybody, and that's what I will continue to do. I also have experience, doing nearly 25 years of civil practice before taking the current position that I have, and currently now I deal with the most complex discovery issues in our community, and I supervise the ADR program. So from my perspective, you have to follow the law, follow the precedent, and make sure that you're continuing to do that. I do have experience on the other side as both plaintiff and defense, and I have done some criminal stuff. I certainly will not say that I'm as experienced in criminal law as Mr. Howell is, but certainly I recognize that this is a civil department. It's a business court department, and I anticipate that it will continue to be that way once I'm elected.
Yeah, I think both gentlemen hit it on the head, is that judges are not legislators, right? Our job is to impartially and unbiasedly follow the law, to apply the facts of the case, the law to the facts of the case. And even if that comes an outcome that we don't personally agree with. Ultimately, the Constitution is the most important part of our criminal justice system. I've fought for that Constitution both literally and now as a public defender for the last 10 years. And I can tell you that it's different being an advocate than being a judge. You have to fight zealously for your clients. And you have to make arguments that sometimes go counter to what you believe the law is or what it should be. But as a judge, it's your job to, well, unpopular or not, apply the law fairly and as it stands today with considering precedent.
Andre Haynes, Armed Forces Chamber. This question is for all of you. Under NRS 200, how would you evaluate sentencing factors in serious felony cases?
Robert Kurth. I'm looking at that. Actually, I'm looking at that right now. I have some people charged under that statute. But you're talking about NRS 200, like serious violent crimes. like murder and child abuse, neglect with substantial bodily harm, and robbery with deadly weapon, things like that. Yes. I'm sorry. How would I do what? I apologize.
It's all right. How would you evaluate the sentencing factors in these types of cases?
Okay. Well, I think in any case, and not just this serious violent crime, you're going to get a report that's going to come to you from the pre-sentence investigation report. It's going to give you the background of the individual. But when you're doing a serious crime, a lot of times people argue before the judge, well, it's their first offense and things like that. And that makes more of a difference in a non-violent crime, right? Not something under NRS 200. It's, a petty theft or, a little drug charge or something like that. But when you're talking about this, what happened? Are there any mitigating factors? Is there any self-defense? Was there any mental health problem? Were they on, if they were on a substance abuse, the fact is they chose to be on that substance abuse probably before they did the act, right? So all of that needs to be considered. What is their background? What is their age? What is their education? Were they a veteran? Do they have PTSD? Are they eligible for some other program or something else? So we just have to consider, all of their background and all of the factors that are involved, including the victims and the victims' rights and what actually happened in that particular situation.
That's the $1 million question, right? It is a true balance. And there are key principles that we need to follow as judges when we're taking those things into consideration. But every case is different, obviously. You do need to consider whether or not rehabilitation is going to be best. You do need to consider restitution. You do need to consider the victims and whether or not deterrence is the answer to what needs to be done, and certainly the retribution that they want for what's happened to them. And I think as a judge, you got to take all that in consideration, as well as the report from parole and probation, and do the best you can to make a really tough decision in some instances. But it's a balance. It's a balance between all those things, and you have to take into consideration. And you hope that you can put a judge up there that is experienced enough to be able to make hard decisions and be able to do the best they can to prepare to make those hard decisions. And once they make their decision, to go with it. Now, we have a system that's allowed for people to appeal if they think we're wrong about something, but certainly you want to make the best decision you can at the time.
So I think what we're all talking about is the totality of the circumstances, right? What we're looking at when you're looking at a case, as any sentencing really, but particularized to NRS 200, is you're looking at the nature of the offense, the criminal history of the person, their substance abuse history, their mental health history, their work history, how they grew up as a child. These are all things that are contained in the pre-sentence investigation report done by the Department of Probation and Parole that is available to the judge prior to sentencing. They used to make recommendations. They don't anymore because ultimately sentencing is up to the judge. It comes down to discretion. And discretion and wise use of discretion comes from experience. Right? Not every offense requires that a person be incarcerated, but some do. A lot of cases require compassion, but it's weighing the factors. It's weighing things like restitution. It's weighing things like what is the victim seeking. It's about being fair to all the parties in the room, but also ultimately protecting our community. Thank you.
J.P. Edwards, Armed Forces Chamber, along that same type of lines. Walk us through how you analyze the dispositive motion under NRCP 56. What evidentiary standards guide your ruling?
Right down my wheelhouse, thanks. So NRCP 56 is obviously the motion for summary judgment, and I just literally taught this when I'm teaching over at UNLV. I teach over at Boyd, and we were just talking about this the other day, the difference between that and a motion to dismiss. Hopefully my students are listening. A little shout out to them. But in which case, the standards are whether or not a reasonable juror, whether or not there's any evidence to support the claims that are being presented. That's the standard. We can get into the nitty gritty of it, but there's a lot of case law out there that talk about that. It's something I've done for 25 years now, and I can tell you that I understand the standards. I teach the standards. I know that you have to make those tough decisions, but there are those judges who like to kick the can down the road. I will not be one of those judges. I will look at the evidence the way it's presented. I will look at the law and determine whether or not there is a sufficiency of evidence in order for that claim to go to a jury at some point in time in the civil arena, obviously.
Right. So I think this is has a lot to do with resources, right? So that's a motion for summary judgment, whether or not there are facts that are sufficient for this case to move forward to a trial. It's an important step towards trial. It's an important thing. It's an important issue that you have to deal with in the civil litigation, which I will admit that I don't have an immense amount of experience in. But when it comes to resources and when it comes to judicial resources, it's important that you be prepared for those hearings, for those, and read the pleadings, and prepared to be decisive. What decision, one way or the other.
Robert Kurth. So Rule 56, I know I was just dealing with that the other day, but for 34 years I've been doing that, and you know that comes up when somebody wants to present to the court and say, hey, according to Rule 56, there's no dispute as to the material facts. We all agree that these particular facts are undisputed, and when we apply to the law, that applies to the case, and you got to make sure you're applying the correct law, okay, and that you understand the law. If you can do that, then a judge should rule on a summary judgment and not be afraid to do it. It appears that some judges, are hesitant to rule on that because they're hesitant on whether or not they're going to get appealed or possibly lose on appeal. But I think it's very important that the judge takes it seriously because there's a lot of litigation. It costs a lot of extra costs for attorney's fees. Just being in litigation, having your client in litigation, whether it's a business, having their employees come in for depositions, things like that. If you can clear it up in a summary judgment motion, you sure want to do that at that time.
Andre Haynes, Armed Forces Chamber. This question is for all three of you. Explain the bail considerations under Nevada law and how you balance public safety versus the presumption of innocence.
All right. So in years past, we used to have a thing called standard bail, where people were getting certain offenses had a certain bail listed to them. Category B felonies are $20,000. Category C felonies $10,000. That changed a few years back by some of the hard work from the Public Defender's Office in litigation in federal court, which created what's called the Valdez-Jimenez case, ruling in that case, which says that judges must make an individualized determination about bail based upon the defendant's ability to pay, the severity of the offense, the threat to the community, the safety of the community, and their return to court. And that bail must be reasonably tailored if they're going to set a bail to ensure both the community safety and return to court. But it should be reasonable and it should be attainable by criminal defendants because just because you have money shouldn't determine whether or not you were in custody pre-trial versus being out.
Go at him. Robert Kurth. So considering bail, what they did is when we're talking about this Valdez-Jimenez, we're talking about somebody having the opportunity now to be on, for instance, electronic monitoring. If they could find a least intrusive way where they can release somebody and they're not going to, like if it's a stalking thing or harassment, you're going to have a no contact order. And if they put them on electronic monitoring, there's different levels of that, okay? Some they just have to check in. Some they're looking at every place you're at the whole time. It's now that costs too, right? Now bail costs because you have to have enough people out there, enough officers that can monitor them and do that. And sometimes when people get the electronic monitoring, they can be sitting in jail for a while just to get that on so they can be released. Bail, when you're talking about, like we're talking about the NRS 200 offenses or category A or B felony, because we have felonies ranging from category A to E. So in a category A or B, a serious crime like that, you're going to still usually get some bail that they're going to have to do to make sure that they're going to show up. But you do have to consider everything. How long have they lived in the community? Do they have family? Do they have a job? Do they have a substance abuse problem, mental health problem? Are they going to come back to court? Because primarily it's to make sure they come back to court. And most people do come back to court. They don't want a warrant. They want to get their case resolved.
I don't really have much to add other than you could kind of see it coming from Justice Hardesty when he wrote that opinion in Valdez-Jimenez, and you can kind of see some of the case law that was leading up to that. And it was the main thing that I think, and also again as being on the bench has kind of showed me a different perspective, is the burdens were kind of shifted at that point in time. The burdens were shifted. Now the burden is on the prosecutor to show why that amount of bail is appropriate in that situation. And I think it's very important as a judge to recognize those burdens and where they lie. it shouldn't be on the individual to show that they are going to come back and how much. I mean, they do have to. The burden does shift to them to show that they can or cannot afford a certain amount that's being proffered. But the reality is that the burden needs to be on the prosecution to determine or to show the judge, and for the judge to be able to make the decision about whether or not that person's going to show back up to court, and the reasons to protect the community. That's part of it too. We can't forget about that. It's also to make sure that the community is being protected in that interim.
He went first. JP Edwards, Armed Forces Chamber. This is for all of you. Describe your approach to maintaining decorum when attorneys engage in repeated speaking objections or grandstanding.
Mr. Kurth, I think you're up.
Okay, I'll go first. Robert Kurth. You see a lot of that as litigants in family court. You see a lot of it. And if I was a judge and that was going on, what I would do is I would not embarrass somebody. I think there's some judges that out there that embarrass people. There's some attorneys that take advantage of other attorneys because they're less experienced or they're new on the job trying to figure things out. And I would bring them up to the bench and have a little a private conversation to make sure they understand that there's a rule that's been adopted of decorum, right, of collegiality, and if they kept doing it, just depends how serious it got, right? But tell them, look, try to focus them in. These are the issues. This is what I would like you to present to me. This is what we need to decide right now. Can we please focus on that? Kind of bring it back down, but do it with a good temperament and demeanor. You don't want to escalate the situation. So be courteous and listen to them.
Decorum is definitely a problem, not only in family court, but civil. Probably not as much in the criminal arena, to be honest with you, from what I have seen. I can tell you it all came to a head for me. I was the discovery commissioner hearing motions in the Dennis Prince and the Houston matter. And that was just a horrific tragedy that looking back at it, you wonder if things could have been done differently and steps could have been taken differently in order to try to de-escalate some of those situations. And I will tell you that in the civil arena, there are provisions that require civility. From my perspective as a judge, I sometimes will actually require people as a sanction, if they are not acting appropriate, to attend a civility CLE in order for them to act better. I make people dress appropriately for court. You would be surprised that is still an issue at this day and age. And to me, that sets the tone. If they don't have the respect for the court, and they don't have the respect to show up dressed appropriately, how are they going to treat the person on the other side of a very hotly contested item? How are they going to do that? And I feel very, very strongly that needs to be controlled by the judge. The judge is the controller of that.
So I think this is temperament, right? You want everybody in the courtroom to respect not only each other, but also the courtroom itself and the role as a judge. I think, like Mr. Kurth, I think you want to de-escalate. You want to bring people up to the branch to talk to them. You don't want to embarrass them in the courtroom. If you need to continue, you can bring them to chambers to talk. Obviously, it escalates to a point where further action may need to be done. Judge Gonzalez, when I appeared in front of her early in my practice, used to make us and the DAs get together for cookies after hours in between if we got into some, contentious hearings and contentious fights. Because ultimately, we're there to serve the people. We're public servants in the courtroom. And it's not about our ego, and it's not about taking it outside of the courtroom. It should be there. You should be able to make your argument with respect of both parties and the court. The respect for the rule of law requires that a certain outcome happens.
Andre Haynes, Armed Forces Chamber. This question is for all of you. What restrictions apply to ex parte communications, and what are the narrow exceptions allowed?
I think this one's It's on me, right? Let me first just add to that last little part because it brought something up with Judge Gonzalez. I've actually had situations, usually with the younger attorneys who have had what I feel to be below the standards of civility within my courtroom. I've taken them out to lunch. I brought them into my chambers and had lunch for them brought. It's very important to me, and I feel very, very strongly that we, as some of the elder attorneys who have been practicing for a lot longer, give back to the community and do that. But let me get to your question, which is restrictions on ex parte. It's pretty clear that you shouldn't talk to one of the other side without the other side being present and on a case. If you do, you need to recuse yourself. If something happens, you see somebody at a supermarket, they mention something about it, they start talking about a case, I immediately will shut people down. You can't talk about cases. I think most attorneys know that is just absolutely inappropriate. As a judge, I will tell you that sometimes the lines are blurred when they call into the office and they talk to staff about certain things. Certain staff members shouldn't be having certain communications with them either because they're part of our administration. So it's a little bit blurred there. But ultimately, if they're talking about scheduling or something else, that's clearly something that we have to do in order to maintain that. But if litigants try to communicate with me as a judge, I will flat out tell them, look, you keep talking and I'm not going to be able to be on the case anymore. I won't be on the case anymore and I'm out of here. So it's a real simple, easy line to draw in the sand.
I think it's pretty clear. There are very few circumstances where ex parte communications are appropriate. For instance, in criminal cases, a lot of times parties will submit ex parte orders to the court that other side won't know about until after they've been granted, particularly when it comes to records that are going to be reviewed in camera and then ultimately likely disseminated through the discovery process to all the parties anyways. So they're going to learn of it eventually, but those are more of orders that are submitted that are typically filed under seal so that the general public doesn't know about it either. Communications between ex parte communications with the judge, that judge should at all times seek to include all parties in that communication. So if you start having that conversation, hold on, let's call counsel, CC them on emails. Get them involved. You see them out in the street. We all have personal relationships with attorneys because we're all attorneys. We're all coming, from that community. And it's a small community. So it's very much self-regulated, I believe. But we should strive to not talk about cases, especially not cases before us, in the role of judge.
Robert Kurth, it's really a short and sweet and simple answer. You cannot have an ex parte communication. You just can't do it. And there are times when somebody might come up, and as long as it cannot be a substantive about anything about the case, but really, you just can't have one because there's an appearance of impropriety. And if that's going on, then you'll probably be, force yourself to just be recused from the bench so that everybody will, look at the decision, everybody will understand the decision, and they'll respect that decision.
J.P. Edwards, Armed Forces Chamber. What is the standard for granting preliminary injunction under Nevada law, and how do you balance irreparable harm versus likelihood of success?
Well, I think you just said it there. Am I first? I don't know if I was first or not. I think you just said it there, irreparable harm versus the need for it in an exigent circumstance, right? Those urgent situations. And I do protective orders all the time. There's standards for protective orders, even in a civil arena where they may not be as timely as some of the other ones in a temporary protective order for a criminal matter. But certainly the standard's the same. There's case law out there. There's factors that need to be considered. And I will tell you that, again, it's a balancing, and you got to make sure that you're taking everything in consideration in order to do that. A lot of times when I get these situations, I will often do temporary orders, but then I will, depending on how exigent the circumstances are, I will set another hearing for a more permanent hearing. For instance, some of these things come up very quickly. You don't have a whole lot of the information in front of you, so you need to make a quick decision on it. You make that decision, but you don't make it permanent right then and there until you've had a better opportunity to review everything. So for me, it's taking all the information in and doing the best you can to make evaluation to where nobody is hurt.
The purpose of a preliminary injunction, Chris Howell, the purpose of a preliminary injunction is to avoid irreparable harm, right? And it should be, at least on its face, things move quick. You're presented with facts, oftentimes from only just one party. Think of a temporary protective order in a domestic violence situation, for instance. and you're still collecting facts, but you need to create a safe environment to prevent that irreparable harm. I think it's important to make that initial determination based upon the facts that you have in front of you, and then also, like Mr. Ganz said, set a time in the future for where you can have both parties come in and argue both sides and see if there's been a difference since the temporary protection order or the injunction was granted, and now has that kept the irreparable harm from occurring? Was the likelihood that it will continue without a permanent injunction? And these are factors to consider.
Robert Kurth. Excuse me. A preliminary injunction, you're primarily talking about what happens in a civil case. I've handled several of those. So you can have one, for instance, you're looking at somebody wanting to sell some property or some real properties in foreclosure. So you might need to enjoin that foreclosure until you can hear the merits of the case, because once that property is sold, then everybody's going to lose everything, right? And then even if they win later on, what are they going to win? What are they going to collect? Where's it going to be? I've had cases where somebody comes in and gets a preliminary injunction to shut down a business. Like, okay, what's the likelihood of success in the end? Are you going to win? Is this business going to be shut down, or can we go in and then modify that and let the business operate, but then put some, other parameters on it? So you have to be very careful in doing it. But it's an important thing. And I've had some judges that should have granted it and didn't. And people have lost their property, or they've lost their way to be able to collect the money that was that they were defrauded from. So thank you.
Andre Haynes, Armed Forces Chamber. This is the final question. It's for all three of you. Why should voters support you instead of your opponent?
Sure. I don't mind going first. So I've been a public servant my entire adult life. I was a combat veteran with multiple deployments to Iraq, literally fighting for our constitutional rights and freedoms on the battlefield. And now, as a public defender for over a decade, I've been in the courtroom representing thousands of clients every single day of my career. I bring a diverse perspective to the court. And when I say diverse, I don't necessarily mean ethnicity or anything like in that regards. And the fact that I'm a veteran, and there's very little representation from veterans on the court. Whereas between family court and district court, there's 56 departments, I believe, total, and very few of those judges have that kind of experience and can understand where people come from. The Constitution is by far the most important aspect of our judicial system. I've fought for it both on the battlefield and in the courtroom. I believe in leadership, loyalty to our shared values, duty to serve, respect for the parties, selfless service, honor, integrity, and personal courage.
Robert, I thought we were going that way. I don't mind. Good way. You want me to go? It's very simple, in my opinion. It's about experience. It's about temperament. It's about day one being ready for the job, and I'm there. I believe that these are fine gentlemen. I have nothing bad to say to them. I actually thank Chris for his service as well as your members to the service to our armed forces, and I truly appreciate everything you've done. I went a different direction. I grew up in Las Vegas, going to public schools. I went away and I left home when I was 15 and a half, and I built a successful career, put myself through college, through law school, built myself a successful career, and actually retired in 2020. And I'm doing this because I want to give back to the community. And in doing so, I'm going to be prepared. I'm going to be ready on day one to be able to do this. I have both the experience. I've argued for the Nevada Supreme Court. I mean, we can talk about our experience, for another couple hours. But the reality is that I am ready, day one, judge ready to take over this department that's a civil department right now.
Robert Kurth. And first, I want to say that I'm thankful for being here today. I'm thankful for the veteran service. I'm thankful for Mr. Howell's service. I know that my grandparents, or two of my grandfathers, served in World War II, and I have a lot of cousins, uncles served in various parts of the armed forces. I did not, but without that, and without the service from the veterans, we wouldn't have the protections and the rights that we have today. Even the establishment of our own Constitution. I've been practicing law for 34 years. I've ran my own practice since 1996. I have judicial experience serving as an arbitrator since 2001. I've also served as a pro tem child support hearing master and a pro tem small claims court judge. I've been involved in the community. I've been, I was the president of the Sagebrush Soccer League one time. I think it makes a difference. You know what's going on, everything that's going on around, involved in scouting. I care about this community. I've raised my kids here who live here and are successful, my grandchildren. And I want to make this community safe. And I want it to make it somewhere where people go to court and they understand they're going to get a judge who's going to listen to them, to listen to their concerns, who's going to uphold the Constitution, who's not going to legislate from the bench, who's going to enforce and respect their rights and protect our families. And that's why I think when you couple all that with my civil experience and my criminal experience, of which I have extensive in both areas, that I believe that I'm the best candidate for this position. Thank you. Would appreciate your vote and your support.
Okay, and we're going to give everybody a chance to have a closing statement for 30 seconds.
Sorry.
30 seconds. Again, thank you for having me. I appreciate that. I'd like to say that I have the endorsements of many community leaders, including Shelley Berkeley. I have the Las Vegas Metropolitan Police Department's endorsements. I have Steve Wolsten's endorsement, the DA. I have the Asian American Group's endorsement. I have the fair and qualified judicial PAC endorsement. I will tell you that the community believes in me. They put me in this position. And I would just say, it's in your hands. Vote for Ganz.
That's a hard act to follow. So it's catchy. Thank you for hosting this interview process and to give us an opportunity to tell you who we are. I am a trial attorney, and I have been my entire career as an attorney. I'm very experienced in the courtroom. I bring that experience to the bench. I'm a veteran. I believe in our Constitution and the rights and our freedoms, and I'm a public servant. And I humbly and respectfully request your endorsement.
Thank you, Robert Kurth. I think we need somebody on the bench who has the experience, who has the integrity, who has the demeanor and the temperament. How are they going to handle their courtroom? How are they going to handle the attorneys, the litigants, the people? Are they going to respect the victims and the defendants and everybody that's there? I'm going to be that person who's going to do that. And I'm going to bring my extensive criminal and civil and judicial experience into that position. And we appreciate your vote and your support. Thank you.
Thank you, gentlemen, for participating and doing an interview. This is the Joint Veterans Endorsement Interviews for Judicial Candidates. We'd like to thank our sponsors, Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds from Department 29. Thank you for watching and listening.
All right.